So that certain nameless person and the organization that they conspired with are now arguing with the judge in New York. Why? Because they don't want to come off the information that they were told that they have to. They're saying that it's unnecessary. It's unduly burdensome. Yeah, it wasn't that when they were conspiring behind the scenes, was it? So hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. So if you're wondering about that argument in New York, why you have that nameless person and their co-conspirators standing up and basically arguing with the judge, that's because they don't want to turn over any records to JD. See, recently they lost a huge battle to JD in which two courts, not one court, but two courts told the ACLU they were going to have to come off of information. See, Virginia was the first court to rule on this. They essentially told the ACLU, you have to turn over everything, and the ACLU, they refused to comply. Now, since the ACLU is headquartered in New York, JD decided he would sue them there, and you know what? He won there too. The courtrooms, they said, you have to comply with this order, and guess what? The ACLU has yet again said, yeah, we're not going to comply with that. See, that's essentially what this filing is here. And when you look at this, notice the name of it, reply in further support of Respondent Anthony Romero's motion to re-argue. You may be asking yourself, who the heck is Anthony Romero? Now, if you notice the people that are listed here, these were all the people being sued in New York. You had the ACLU, like I said. Well, you had two non-parties that were working with them. You had Benjamin Weiser and you had Anthony Romero. Anthony Romero is basically the stopgap right now. You have that nameless person and you have the ACLU trying to use his name so they don't have to come off of any information whatsoever. It's always the same thing. I don't want to come off of this. I'm not going to comply. Here's yet another way that we're going to try to stop this stuff, because this stuff here, it is damaging and beyond. Now, you and I, we're going to break this document down, and I love the way that they're trying to argue this. Why? Because now they're trying to say that all of this stuff is unnecessary and it's unduly burdensome on Mr. Romero. Mr. Romero was one of the people that was plotting with a certain person behind the scenes, helping them put what was essentially a hit piece together, making someone the Violence Against Women Act's masthead, as it were. Can you imagine what that would do to your life? That was okay behind the scenes, but now that it's exposed to light, now it's unduly burdensome. Now, I like this document, by the way. Why? Because right from go, you can tell what the ACLU is afraid of, and that is Anthony Romero getting out, not being prepped enough yet, and basically giving away the ghost, as it were. You can see in part 1 here, look at this headline, re-argument of the ruling on Mr. Romero's deposition is warranted. So, they don't even want him deposed. They don't want him talking about anything at all. They want to argue that he and he alone, that's an interesting thing, isn't it, by the way? He alone shouldn't be out there talking about this stuff at all. Quote, re-argument is warranted when the court overlooks a matter of fact or law. JD's opposition confirms that Mr. Romero's argument that his deposition is unnecessary was, quote unquote, indisputably presented to the court in parties' briefings on JD's position and was, quote, not explicitly addressed in the court's 2-page decision. For these reasons, Mr. Romero respectfully submits that the court may have overlooked Mr. Romero's presentation of fact and law on the issue of Mr. Romero's deposition, making re-argument appropriate. So you see the play that they're doing here. They're saying, well, this stuff, it was brought up, but in the decision, this isn't specifically named, even though everybody is named in the header. They're all being decided against. But hey, for that fact right there, we need to be able to defy the court's order. Yeah, not gonna work. Now, the second part here, Romero's deposition being unnecessary and unduly burdensome, really tell you the game that's being played. Like I said, they're afraid of what this man is going to say. They want to put up people that are more qualified not to say the wrong things, and they give this away very well in the document here. On re-argument, the court should deny the petition to the extent it seeks to compel Mr. Romero's deposition. To be clear, Mr. Romero does not seek re-argument of the portion the decision holding on certain topics, including that nameless person's donations are within the scope of discovery. And Mr. Romero does not dispute that he had communications with that nameless person about her donations, which Mr. Romero and the ACLU have begun producing to JD. But even accepting those facts, JD has still failed to show that Mr. Romero's deposition is necessary, given that the ACLU will produce 2 other witnesses for deposition, including a corporate representative who will be prepared to testify as to corporate knowledge, including Mr. Romero's knowledge, on the topics set forth in the deposition subpoenas. Moreover, JD does not dispute that the burdens on Mr. Romero to prepare for and attend a deposition would be substantial. In the light of the fact that the ACLU is already producing multiple witnesses for depositions, such further burdens are unnecessary and inappropriate. Again, all of this stuff, it was appropriate and it was necessary when they were plotting behind the scenes. They admit that. You see them admit to it. But now they don't want him talking because, again, he knows about a lot more than this, and you can tell. Now, if that doesn't make the idea that they don't want Romero speaking clear enough, well, this part, it tells you and then some. Quote, any communications Mr. Romero had with that certain nameless person were undertaken in his role as the ACLU's executive director and therefore can be fully presented as a corporate representative witness who will have access to Mr. Romero's knowledge as well as the knowledge of the ACLU's development office that manages donations, aka somebody else can speak, anybody else, just not Romero. Then they tell you, JD, he argues that Mr. Romero possesses relevant information to which others at the ACLU were not privy, and they say, even if that were true, even if that happened, there's no reason to expect that an ACLU corporate representative could not be prepared to testify as the information that Mr. Romero obtained in his role as the ACLU's executive director. So, he may have had private conversations, only one-on-ones that he would know about, but don't let that bother you here. We need to shut this down. We need to shut it down now. They try quite a few other questionable arguments, too, to the point that JD's team has said that Mr. Romero and the ACLU, they feel that they're immune from discovery. They don't like that either, but you know what? They're still arguing with judges, still arguing with multiple jurisdictions, still not coming off of what they were told to. They don't want this guy speaking. Like I said, he knows the wrong thing. They're afraid it's going to come out. So yeah, you tell me. But anyway, let me know what you think about this. And as always, appreciate the heck out of you. You make this stuff work. Thank you. Want to help out the channel? Links in the description. You know that drill here. But you being here, that matters. So thank you. Appreciate you. Going to end here. Thank you again.